Join me as I dive into the secrets of the Supreme Court to see if I can become a successful lawyer faster than ever. Hi, I am Advocate Dr. Saurabh Kapoor bringing you a video on this fascinating topic like this. But before you start watching this video, I request you to kindly like, subscribe and hit the bell icon to my YouTube channel to view videos like this more. Please leave a comment below telling your thought and idea about this video and future videos you want. Unlock the secrets to a successful legal career by mastering the art of judicial insights and legal mastery. In this video, we'll dive into the world of court mastery, providing you with expert legal mentorship and strategies to supercharge your legal career. From case analysis to courtroom techniques, we'll share attorney tips and legal secrets to help you advance in your judicial career. Whether you're a law student looking for law school tips or an experienced lawyer seeking professional development, this video is designed to help you achieve lawyer success. By applying the legal skills and judicial insights shared in this video, you'll be well on your way to achieving career growth and career advancement in the legal field. Tune in to discover the Supreme Court secrets that will take your legal career to the next level. If you're a law student or a young lawyer, you're probably wondering how to accelerate your career and gain credibility in a competitive field. The truth is, understanding the secrets of the Supreme Court can give you a significant edge in the legal world. By leveraging these insights, you can not only stay ahead of the curve but also build a successful and fulfilling legal career. Many new lawyers struggle to build their careers due to a lack of experience, limited network, and intense competition. As a result, they often get stuck in low-paying jobs or struggle to find clients. Moreover, with the ever-changing legal landscape, it's becoming increasingly difficult for new lawyers to stay relevant and competitive. The pressure to perform can be overwhelming, leading to burnout and frustration. On top of that, the fear of making mistakes and facing rejection can hold them back from taking risks and pursuing their goals. The bottom line is, building a successful legal career takes more than just a law degree and a passing bar exam. It requires strategic thinking, creativity, and a deep understanding of the legal system. Unfortunately, many law schools and legal programs often fail to provide students with the practical skills and knowledge needed to succeed in the real world. As a result, new lawyers are often left to figure things out on their own, which can lead to costly mistakes and wasted time. Furthermore, the legal industry is constantly evolving, and those who fail to adapt and innovate will be left behind. The successful lawyers are those who stay ahead of the curve, who understand the game-changing decisions of the Supreme Court, and who can think critically and strategically. The organic element of law. The inevitable truth is that law is not static and immutable but ever increasingly dynamic and grows with the ongoing passage of time. S. Ratnavel Pandian, J. In Supreme Court Advocates on Record Association vs. Union of India 4 SCC 441. One crucial tip that successful lawyers use to master Supreme Court secrets is to develop a deep understanding of the court's precedents and procedures. By studying the court's decisions and understanding the justices' reasoning, lawyers can develop a more nuanced understanding of the law and anticipate how the court will rule in future cases. This allows them to develop more effective legal strategies and stay ahead of the competition. For instance, understanding the court's decision in Chevron v. Natural Resources Defense Counsel can help lawyers navigate complex regulatory issues and develop more effective legal arguments. Great judgment versus landmark judgment. A great judgment is one that restores the constitutional values of a polity from the waywardness into which it may have fallen, while a landmark judgment is one which opens up new directions in our Constitution. Our thinking and, in the process, adds new dimensions to what are regarded as established constitutional principles. If great restores the centrality of constitutional values, landmark revitalizes them. Peter Ronald D'Souza, professor at the Center for the Study of Developing Societies, Delhi. Landmark judgments. When histories of nations are written and critiqued, there are judicial decisions at the forefront of liberty. Yet others have to be consigned to the archives, reflective of what was, but should never have been. D.Y. Chandrachud J. In Justice K.S. Puttaswamy vs. Union of India and Ors. 10 SCC 1. Personal liberty. Procedure established by law. A.K. Gopalan vs. State of Madras. SCR 88. The petitioner, detained under the Preventive Detention Act, challenged the legality of detention under Art. 32. The Constitution on the ground that the said act have contravened Arts. 13, 19, 21 and 22 of the Constitution and was, therefore, ultra vires. The SC held that Article 22 was a self-contained code, and if personal liberty is taken away by the state in accordance with the procedure established by law, i.e. if the detention was as per the procedure established by law, then it cannot be said that the law is violative of provisions contained in Articles 14, 19 and 21 of the Constitution. Personal liberty, procedure established by law, fair, just and reasonable. Maneka Gandhi v. Union of India. The view expressed in A.K. Gopalan's case was revisited in this case after about 28 years. The main issues were whether the right to go abroad is a part of the right to personal liberty under Article 21 and whether the Passport Act prescribes a procedure as required by Article 21 of the Constitution. The SC held that the right to go abroad is a part of the right to personal liberty under Article 21. The SC also ruled that the mere existence of an enabling law was not enough to restrain personal liberty. The procedure prescribed by law has to be fair, just and reasonable, not fanciful, oppressive or arbitrary. Amendability of fundamental rights. Shankari Prasad v. Union of India, SCR 89. This case dealt with the amendability of fundamental rights, the First Amendment's validity was challenged. The SC court held that the power conferred on Parliament by Art. 368 to amend is a very wide power and includes the power to take away the fundamental rights guaranteed by Part 3, and that in the context of Art. 13. Law must be taken to mean rules or regulations made in exercise of ordinary legislative power and not amendments to the Constitution made in the exercise of constituent power, with the result that Art. 13 amendments made under Art. Does not affect 368. This view was reiterated in Sajan Singh vs. State of Rajasthan, Air 1965 SC 845. Amendability of fundamental rights. The issues regarding power of the Parliament to amend Part 3 of the Constitution was re-examined in IC Golok Nath v. State of Punjab, Air 1967 SC 1643. The questions in this case were whether amendment is a law within the meaning of Art. 13 of the Constitution of India, and whether fundamental rights can be amended by the Parliament. Overruling Sajan Singh by a majority of 6 to 5, the Supreme Court held that amendment under Article 368 is law within the meaning of Article 13. It further ruled that legislature does not enjoy the power to amend Part 3 of the Constitution to take away or abridge fundamental rights. The doctrine of basic structure is Holiness Xavananda Bharati Sripada Galavaru v. State of Kerala, Air 1973 SC 1461, the most celebrated case in the history of Indian constitutional law, in which the apex court dealt with the issue whether the Parliament can amend any part of the Constitution and what was the limit to that power. The bench by a majority of 7 to 6 overruled the proposition of law propounded in IC Golok Nath v. State of Punjab, Air 1967 SC 1643 and held that constitutional amendment is not law within the meaning of Article 13, and that although no part of the Constitution, including Part 3 comprising of fundamental rights, was beyond the Parliament's amending power, the basic structure of the Constitution could not be abrogated even by a constitutional amendment. As regards the basic structure, the court held that it would be decided from case to case. The doctrine of basic structure application. Indira Nehru Gandhi v. Raj Narain 1975 SC 2299, the validity of 39th Constitution Amendment enacted in 1975, which sought to place the election of the President, the Vice President, the Prime Minister and the Speaker of the Lok Sabha beyond the scrutiny of the constitutional courts, was challenged in this case. The SC, resorting to the theory of basic structure of the Constitution, struck down clause of Article 329A on the grounds that it was beyond the Parliament's amending power as it destroyed the basic structure of the Constitution. The doctrine of basic structure. Minerva Mills case, Air 1980 SC 1789, validity of Constitution Act, 1976, which inter alia provided for exclusion of judicial review of constitutional amendments and expressly conferred unlimited amendment power to the Parliament, was challenged on the ground that they are violative of the basic structure of the Constitution. The court by a majority of 4 to 1 struck down clauses and of Article 368, holding that they violated the basic structure of the Constitution. The court ruled that Parliament's power to make constitutional amendments is limited, which itself is a basic feature of the Constitution. The judgment makes it clear that the Constitution, and not the Parliament, is supreme. The doctrine of basic structure. Ir Cuello's case 2 SCC 1, basic structure, a landmark judgment on the interpretation of the doctrine of basic structure of the Constitution. The supremacy of the Constitution mandates all constitutional bodies to comply with the provisions of the Constitution. Judicial review, a mechanism for testing the validity of legislative acts through an independent organ, viz. The judiciary is part of basic structure. The court held that any law inserted in the 9th schedule on or after April 24, 1973 can be subject to judicial review and will be struck down if it violates the basic structure doctrine. Public interest litigation. The beginning. Mumbai Kamgar Sabha, Bombay, Air 1976 SC 1455. This case is considered to be the foundation of public interest litigation in India. In this case, Justice V.R. Krishna Iyer, speaking for the court, held that procedural prescriptions are handmaids, not mistresses, of justice. Our adjectival branch of jurisprudence, by and large, deals not with sophisticated litigants but the rural poor, the urban lay and the weaker societal segments for whom law will be an added terror. Test litigations, representative actions, pro bono publico and like broad forms of legal proceedings are in keeping with the current accent on justice to the common man and a necessary disincentive to those who wish to bypass the real issues on the merits by suspect reliance on peripheral procedural shortcomings. Public interest litigation, Sunil Batra v. Delhi Administration and others, Air 1978 SC 1675, a landmark decision on prison reforms. In this case, the apex court held that a convict is entitled to the precious right guaranteed by Art. 21 that he shall not be deprived of his life or personal liberty except according to the procedure established by law. The court ruled that fundamental rights do not flee the person as he enters the prison, although they may suffer shrinkage necessitated by incarceration. Our constitutional culture has now crystallized in favor of prison justice and judicial jurisdiction, the intervention of social welfare organizations and litigative processes pregnant with wider implications is a healthy mediation between the people and the rule of law. The court issued a number of directions for improving the conditions of jail inmates. Public interest litigation, Bandwa Mukti Morcha v. Union of India, 3 SCC 161 in a matter concerning release of bonded labor raised by way of PIL. The Supreme Court issued direction for their release. Explaining the philosophy underlying PIL, the court ruled that where a person or class of persons to whom legal injury is caused by reason of violation of a fundamental right is unable to approach the court of judicial redress on account of poverty or disability or socially or economically disadvantaged position, any member of the public acting bona fide can move the court for relief under Article 32 and a fortiori also under Article 226, so that the fundamental rights may be meaningful not only for the rich but also for the deprived people who by reason of lack of awareness, assertiveness and resources are unable to seek judicial redress. Human rights, Art. 21 Right to die with dignity. In this case, the victim of rape continued to be in persistent vegetative state for a period of 36 years. This case triggered the debate on need to change euthanasia laws. In a writ petition under Article 32, it was prayed that the hospital where she is laying for last 36 years be directed to stop the life support system. The Supreme Court ruled that individuals had a right to die with dignity. Issuing guidelines regarding passive euthanasia, the court ruled that a decision to discontinue life support can be taken either by the parents or the spouse or other close relatives, or in the absence of any of them, even by a person or a body of persons acting as a next friend or in their absence by the doctors attending the patient, subject to approval of the High Court. Human rights, Common Cause vs. Union of India on 9 March 2018. Right to die with dignity. The apex court held that right to life and liberty as envisaged under Article 21 of the Constitution encompasses within its sphere individual dignity, and that the right to live with dignity also includes the smoothing of the process of dying in case of a terminally ill patient or a person in PVS with no hope of recovery, and that a competent person who has come of age has the right to refuse specific treatment or all treatment or opt for an alternative treatment, even if such decision entails a risk of death. Detailed directions issued by the apex court in this regard. Human rights, recognition of transgender persons as a third gender. National Legal Services Authority vs. Union of India and ORS. Held, gender identity is integral to the dignity of an individual and is at the core of personal autonomy and self-determination, and Article 14, 19 and 21 of the Constitution within their sweep include transgender and are not as such limited to male or female gender. Eunuchs, therefore, have to be considered as third gender, over and above binary genders under our Constitution and the laws. The apex court directed the center and the state governments to take steps to treat them as socially and educationally backward classes of citizens and extend all kinds of reservation in cases of admission in educational institutions and for public appointments. Number 400 of 2012 DT.15.04.14. Human rights, right to privacy, a fundamental right under Article 21. Justice K.S. Puttaswamy vs. Union of India and ORS. 10 SCC 1. In this case, popularly known as Aadhaar case, the SC held that privacy is a constitutionally protected right which emerges primarily from the guarantee of life and personal liberty in Article 21 of the Constitution. Further held that elements of privacy also arise in varying contexts from the other facets of freedom and dignity recognized and guaranteed by the fundamental rights contained in Part 3. Human rights, decriminalizing homosexuality. Navtej Singh Johar vs. Union of India. 10 SCC 1. A 5-judge SC bench gave a historic, unanimous decision on Section 377 of the Indian Penal Code, decriminalizing homosexuality. The SC ruled that sexual orientation is an intrinsic element of liberty, dignity, privacy, individual autonomy and equality, and that intimacy between consenting adults of the same sex is beyond the legitimate interests of the state. Section 377 was the product of the Victorian era, with its attendant moral values. Victorian morality must give way to constitutional morality, that insofar as Section 377 criminalizes consensual sexual acts of adults in private, is violative of Articles 14, 15, 19, and 21 of the Constitution. Gender justice, Shah Bano's case a milestone in the journey of gender justice. Petitioner Shah Bano Begum prayed for grant of maintenance under Section 125 of CR.P.C. The Constitution Bench of the Apex Court, considering the provision of Section 125 of the CR.P.C., opined that the said provision is truly secular in character and is different from the personal law of the parties. The court further held that such provisions are essentially of a prophylactic character and cut across the barriers of religion. The court also held that the liability imposed by Section 125 to maintain close relatives, who are indigent, is founded upon the individual's obligation to the society to prevent vagrancy and destitution. Gender justice preventing sexual harassment at workplace. Vishaka vs. State of Rajasthan. 6 SCC 241 Banwari Devi, a social worker from Rajasthan, was brutally gang-raped by 5 men for preventing a child marriage. The trial court acquitted all 5 accused. Vishaka, a group for women's education and research, took up the cause of Banwari Devi and filed a petition before the Supreme Court on the issue of sexual harassment at the workplace. On August 13, 1997, the Apex Court issued guidelines that define sexual harassment and put the onus on the employers as well as other responsible persons or institutions to provide a safe working environment for women. These guidelines are called Vishaka Guidelines. These were to be considered law until appropriate legislation was enacted. Gender justice, triple talaq unconstitutional. Shera Bano vs. Union of India and Ors vs. Union of India 22nd of August, 2017, the court held by a majority of 3-2 that triple talaq is manifestly arbitrary in the sense that the marital tie can be broken capriciously and whimsically by a Muslim man without any attempt at reconciliation so as to save it. This form of talaq must, therefore, be held to be violative of the fundamental right contained under Article 14 of the Constitution of India. Gender justice, entry of females in Sabrimala Temple. Indian Young Lawyers Association vs. the State of Kerala. On 28 September, 2018, in Sabrimala Temple, a Hindu pilgrimage center in Kerala, female devotees between the age group of 10 to 50 years were denied entry on the basis of certain custom and usage. A constitution bench of the Apex Court led by CJI Deepak Misra overruled the Kerala High Court's 27-year-old decision that had upheld the restriction on entry of women into the temple. The court said, the dualism that persists in religion by glorifying and venerating women as goddesses on one hand and by imposing rigorous sanctions on the other hand in matters of devotion has to be abandoned. Such a dualistic approach and an entrenched mindset results in indignity to women and the degradation of their status. Gender justice, Sec. 497 IPC unconstitutional. Joseph Shine vs. Union of India, 3 SCC 39. The Apex Court struck down Section 497 of IPC, which criminalized adultery, holding that it is violative of Articles 14, 15 and 21 of the Constitution. The Supreme Court called the law unconstitutional because it treats a husband as the master. The court held any provision of law affecting individual dignity and equality of women invites the wrath of the Constitution. It's time to say that the husband is not the master of the wife. Legal sovereignty of one sex over other sex is wrong. Constitutional democracy, power under Art. 356 imposition of President's rule in states, S. Arbamai v. Union of India, Air 1994 SC 1918. In this judgment, the SC attempted to curb the blatant misuse of Article 356 of the Constitution of India, which allowed President's rule to be imposed in states. The first and most important question which the Supreme Court had to determine was whether the presidential proclamation under Article 356 was justifiable and if so to what extent. Answering the question, the Apex Court held, the judicial review will involve 3 questions only. Is there any material behind the proclamation? Is the material relevant? Was there any mollified use of power? The majority enjoyed by the Council of Ministers shall be tested on the floor of the House. Constitutional democracy, election reforms. Right not to vote. Note a case. The SC dealing with the issue of election reforms held that democracy and free elections are part of the basic structure of the Constitution. In a parliamentary democracy, a positive right not to vote is a part of voters' right to expression under Article 19, and it has to be recognized and given effect to in the same manner as right to vote. The only way by which it can be made effectual is by providing a button in the EVMs to express that right. Therefore, the voter must be given an opportunity to choose none of the above button, which will indeed compel the political parties to nominate a sound candidate. Constitutional Democracy, Election Reforms Lily Thomas vs. Union of India and Ors. 7 SCC 653. In this case the Supreme Court in a PIL declared subsection of Section 8 of the Representation of the People Act, 1951, which allowed convicted members of legislative bodies a 3-month time period for appeal against the conviction and sentencing. As ultra vires the Constitution, the court ruled that members of Parliament, legislative councils and legislative assemblies convicted of crimes where they had been awarded a minimum sentence of 2 years imprisonment would cease to be members of the House to which they were elected from the date of sentencing. Independence of Judiciary. First Judge's Case in Consultation. Interpretation S.P. Gupta vs. Union of India and Ors. Air 1982 SC 149. In this case the SC was called upon to examine as to what does the word consultation in Article 124 and in Article 217 of the Constitution actually imply? The Apex Court held by a majority of 4-3 that in the appointment of a judge of the Supreme Court or the High Court, the word consultation in Article 124 and in Article 217 of the Constitution does not mean concurrence. However, the consultation with the CJI must be full and effective. The Apex Court rejected the idea that the CJI's opinion should have primacy, and held that in the event of a disagreement, the ultimate power would rest with the Union government and not the CJI. Independence of Judiciary. Second Judge's Case. Birth of Collegium System. Supreme Court Advocates on Record Association vs. Union of India 4 SCC 441. This verdict gave birth to the concept of Collegium System. A 9 Judges Bench of the Apex Court, re-examining the view expressed in the first Judge's Case by a majority of 7-2, ruled that Articles 124 and 217 of the Constitution had to be interpreted in a purposive and contextual manner. The court held that there should be a collegium consisting of Chief Justice and 2 other senior-most judges of the Supreme Court for making proposal and appointment of judges. The Apex Court held that in the event of conflict between the President and the CJI with regard to appointments of judges, it was the Chief Justice of India whose opinion would not only have primacy, but would be determinative in the matter. Independence of Judiciary. Third Judge's Case. Strengthening of Collegium. In Re Special Reference Case Air 1999 SC 1, this case arose out of a reference made by the President of India under Article 143 of the Constitution for advisory opinion of the Supreme Court. A 9-judge bench of the Supreme Court delivered a unanimous opinion and reaffirmed its verdict rendered in Second Judge's Case. The only thing that this reference introduced from the Second Judge's Case was to increase the number of the judges in the Collegium. The Collegium was now to consist of the CJI and the 4 other senior-most judges of the Supreme Court. Independence of Judiciary. Fourth Judge's Case. Supreme Court Advocates on Record Association v. Union of India. The Constitution Act, 2014 and the NYAC Act, 2014 sought to replace the collegium system with the National Judicial Appointments Commission, a body comprising of the CJI, 2 senior judges, the law minister and 2 eminent personalities appointed by the Prime Minister, Leader of Opposition and CJI. The constitutional validity of the 99th Constitutional Amendment and NYAC Act, 2014, was challenged before the Apex Court. A Constitution bench of 5 judges with a majority of 4-1 struck down the 99th Constitutional Amendment Act and the NYAC Act as unconstitutional, holding that the constitution of the Commission will amount to an infringement of judicial independence and a violation of the separation of powers. Environmental Protection. MC Mehta v. Union of India, Air 1987 SC 1086. In this case, popularly known as the Oleum gas leak case, the Supreme Court disapproved the strict liability test enunciated in the English case of Rylands v. Fletcher for deciding the liability of an enterprise engaged in a hazardous or inherently dangerous activity and propounded the principle of absolute liability. The court held that in the case of industries engaged in hazardous or inherently dangerous activities, absolute liability was to be followed. It also said that the amount of compensation must be correlated to the magnitude and capacity of the industry so that it will be a deterrent. Social justice, 50% threshold in reservations and exclusion of creamy layer, Indra Sawhney etc. versus Union of India and others, Air 1993 SC 477. The Apex Court examined the scope of Article 16 of the Constitution, which provides for the reservation of jobs in favor of backward classes, and held that backward classes mentioned in Article 16 can be identified only on the basis of caste and not economic conditions. It upheld the constitutional validity of 27% reservation for the OBCs with certain conditions, the propositions of 50% threshold in reservations, the bar against reservations in certain types of posts, and the exclusion of creamy layer were propounded in this case. Moreover, successful lawyers use the Supreme Court's decisions to anticipate changes in the legal landscape and adapt their strategies accordingly. By staying up to date on the court's latest decisions and understanding their implications, lawyers can stay ahead of the curve and capitalize on emerging trends and opportunities. This allows them to build a successful and fulfilling legal career and achieve their goals faster than ever. In conclusion, mastering Supreme Court secrets is crucial for building a successful legal career. By understanding the court's decisions and precedents, lawyers can develop a more nuanced understanding of the law, anticipate changes in the legal landscape, and develop more effective legal strategies. Remember, the key to success lies in staying ahead of the curve and adapting to the ever-changing legal landscape. What do you think about the Supreme Court's influence on law? Share your thoughts in the comments below, and don't forget to watch my next video on legal career tips.